Welcome. I'm Ada Kay.
Your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of Java and let's dive in.
Hey, welcome everybody. I'm Ada Kay, and we're here for the Donna Adelson emergency hearing. Now, I got to let y'all know I've got 3 lives going on at one time, so you will see me talking, and you won't hear me. It's okay. I'm talking on another live. We've got 3 lives going right now. We've got the Wolfenbarger trial. We've got the Ali sentencing, and we're ready for the emergency Donna Adelson hearing. So we've got a lot happening today. So I know I'm getting it. There we go. It didn't cut off. Thank you. Sorry about that. So we got all of that going on at one time right now. It's a little bit of a crazy day, but you know what? I can do this. So we are literally waiting for the Donna Adelson to pop up. So I'm going to leave this going. You will see me. You may not hear me, but that's okay. We are waiting. Okay, so I have exited out of the other ones just so I can try to figure out what is going on today. We have a lot going on today. I'm going to figure out what is happening with this emergency hearing. Donna Adelson trial never ceases to disappoint. So I am trying to figure out all the details. Hi, Pam the Carmel. Thank you, Pamel the Carmel. Thank you so much for joining us. So the emergency hearing for the Donna Adelson case is as follows. Will be held today. The eve of jury selection for her Red Room trial is centered on a high-stakes legal battle over whether her daughter, Wendy Adelson, must testify under the defense's subpoena. So the defense subpoena versus the state subpoena. Wendy Adelson is already expected to testify under the state subpoena, which grants her immunity from prosecution. However, Donna Adelson defense team also issued a subpoena. Oh, we have battling subpoenas, y'all. We got battling subpoenas, and if you don't say that carefully, you can get in trouble. So Wendy Adelson is already expected to testify under the state subpoena, which granted her immunity from the prosecution. Okay, so this granted her immunity if she testified against her mother. However, Donna Adelson's defense team also issued a subpoena which does not offer any immunity. Wendy's attorney, Mr. John LaRoe, filed a motion to squash the defense's subpoena, arguing she would have otherwise invoked her Fifth Amendment rights. So if she invokes her Fifth Amendment rights, what is it going to do? It could cause a mistrial. Yeah. So this is very difficult, very, very, very interesting and tough situation. The implications for the trial strategy is the defense likely wants to question Wendy Adelson more aggressively than the state would, possibly to challenge her credibility and explore the alternative narrative about the 2014 Red Room for hire of her husband, then Dan Markel, or ex-husband, then Dan Markel, and Donna Adelson's former son-in-law. So Donna Adelson is charged with first-degree Red Room conspiracy and solicitation. Prosecutors allege that after Wendy not very friendly divorce from Mr. Markel, the Adelson family wanted him eliminated so she could relocate with her children to South Florida. Donna's son, Charlie Adelson, was convicted in 2023 for the same crimes and is serving a life sentence. So we will be going into that live um, hearing when it does start. So right now, I'm just going to throw on a little bit of music. We're going to wait. I have two other trials that I'm literally live on right now, and I'm bouncing between all three. So I'm just going to put on a little bit of comfort music, and we will be waiting for this trial to begin. Thank you so very much. I shall return in just a moment. No, no, that's not what I want. I wanted this. I'll be right back. So right now I'm talking to two separate lives. I'm talking in the Ali sentencing trial, and I'm speaking in the Donna Adelson emergency motion hearing. This motion is really an important one because Wendy is protected under the prosecution subpoena because Wendy is going to testify against her mother, so she's turning state witness. But under the subpoena for the defense, there is no immunity. And if she gets on the stand and pleads the fifth, then it can put this trial in a mistrial. So this is a very, very big and important hearing today. So we're going to watch that. I will have that up and running as well. But I want to thank everybody who has been tuning in, all three lives. Right now, Christopher Wolfenbarger trial, day 3. We are in a lunch break. This old lady on the stand is a hoot. I really like her. Then we are also watching the Ali sentencing, which to me is taking freaking forever. I don't know why it's being drawn out so long. And then I have just started a live stream for the up and coming emergency motion hearing that should be starting very shortly. It was supposed to start at 12:30. It is 12:33, so we'll see what happens. But I want to thank everybody for joining. Now, if I start having internet problems because I have 3 lives going at once, probably do 4. That would be a fun trip. I will drop the Wolfbarger trial and come back to that. But right now, everything is good, hunky-dory, and fine. And I'm happy to be doing this. But thank you, everybody, for joining us. Again, for those who are new, I'm Ada Kay. I am your deaf courtroom commentator. I am deaf without these big bad mamas. When my interpreter is not on vacay in Alaska, she is interpreting for me. Hallelujah! Here, court is starting. Hallelujah! Ooh, lunch here too. In order lunch.
Have reviewed your motion, Mr. Loro, concerning the defense's subpoena as far as placing a statement on the record. I don't know if any of the parties have a position concerning you placing a statement on the record, but similar to the other trials in this matter, I do not have an issue if you do so prior to the testimony of your client. As to the placing the statement on the record, does the state have a position?
No objection, Your Honor.
Does the defense have a position?
No position, Your Honor.
Concerning placing a statement on the record, Mr. Loro, you will be permitted to do so, or another member of your firm, before your client testifies. As to the motion to quash the defense subpoena, does the state have a position?
No, Your Honor. No position.
Does the defense have a position?
Yes, Judge.
Go ahead.
May I stay here?
You may.
Judge, the issue here and the concern that we have on behalf of Mrs. Adelson is there have been 2 prior rulings in the homicide of Mr. Markel. One came from Judge Hankinson, and then another one came from Judge Wheeler. What Judge Hankinson ruled is that the immunity conferred by the state subpoena extended to cross-examination, And we believe that's an accurate statement of the law. However, Judge Wheeler limited cross-examination to only what the state brings forth on direct. This is a premature at this point, Judge. We have her under subpoena, and we may want to elicit testimony from her.
Well, before we get there on that point, when she's called as a state witness and she is cross-examined, she can be cross-examined on all matters raised by the direct and on matters of bias or impeachment or motive to lie. All matters that she can be cross-examined on pursuant to the rules of evidence extend under that state subpoena.
I understand that, Judge, but our issue is, suppose that she's one of the first witnesses to testify, and suppose after she testifies, other issues come up that we know, if we called her, she could rebut what has been said. It's not necessarily, it would be something that she would need to invoke her rights. It could be a very simple issue, and we would need her testimony. So until we go through the trial to see what happens, it's impossible for us to say, yes, just cross-examining her on bias and credibility and whatever the state has asked about sounds good in the state's case until we hear further testimony and some issue arises.
I'll allow Mr. Lawyer to make his argument, but the crux of his motion is you cannot offer this witness any protection as it relates to you calling her in your case in chief. What is your response to the written argument on that matter?
Yes, Your Honor.
Hold on, Mr. Lawyer. I'm going to allow Ms. Fulford.
I'm sorry, I thought you were asking me. I'm sorry, sir.
You can make your argument in just a moment.
Yeah, so the issue as to immunity, we cannot confer immunity to her, Judge. We agree with that. We can't. But there may be other issues where she could testify to something that she's not taking a chance, if you will, that she's going to say something that could be used against her in the future. There could be other matters that are raised in the trial that we simply want to get testimony from her as. She is the daughter of our client.
From the perspective of your client, I certainly understand the argument you're making. Mr. Lawyer, you may argue.
Yes, Your Honor. This issue was addressed by Judge Wheeler in the second McBanawa trial. It was also decided upon by the first DCA in July 2025, when the DCA ruled that the procedure used by Judge Wheeler was entirely correct, and the subpoena in that case was quashed. It was the same issue that the defense raised, where they wanted to cross-examine my client pursuant to a defense subpoena, which conferred no immunity at all on Ms. Adelson. I indicated to the court then, as I will now, that Ms. Adelson will assert her Fifth Amendment rights with respect to any relevant question asked by the defense. So the only result of the defense procedure would be to have the client's daughter take the stand and invoke the Fifth Amendment in front of the jury. And that the court decided by Judge Wheeler that that would be inappropriate. And we would ask the court now to follow the same procedure as Judge Wheeler and follow the same procedure that was upheld by the first DCA just 1 month ago.
Does the defense have any remaining argument on this matter?
Your Honor, respectfully, the issue that was ruled on or concerning the subpoena and quashing the subpoena, Ms. McBanawa did not make that argument below. She did not join the state's motion. So the first DCA did not rule that Judge Wheeler followed the proper procedure. My understanding is that the first DCA held that she had not preserved the argument.
And if I could add one thing further.
We don't have tag team motions. Who's going to finish the argument?
Just a moment, Your Honor. Your Honor, factually, we're in a vastly different circumstance. Our client certainly has information, knows information about her daughter that Ms. McBanawa would not have ever been able to know. And so it's our position that it's premature. The Fifth Amendment question, the courts have ruled, should be done on a question-by-question basis.
So your expectation is for me to ask the question, she will make some sort of signal I'm invoking, the jury is to be removed, and then we do this for the entire defense direct?
No, Your Honor. What I would suggest is that if we get into this posture, and absolutely cross-examination may be sufficient, but if we get into the posture of needing additional, I would suggest that potentially proffering the questions, and then she and her counsel can advise the court if she intends to invoke her privilege at that time.
Mr. Laura, last word, and then I will rule.
Yes, Your Honor. The statement by counsel is patently incorrect and false. This issue was raised by Ms. Carras in the McMonaghan trial. She preserved the issue. She made the same arguments that these defense lawyers are making now. It was wholly rejected by Judge Wheeler
That mic is horrible, and I've done the best I can. I apologize.
and wholly rejected by the first DCA. And we respectfully request that Your Honor follow that ruling here. There's simply no question that the defense could ask that is relevant to this matter that Ms. Adelson, my client, would answer. She's invoking her Fifth Amendment.
All right, having reviewed the applicable authority on this issue and also reviewed the prior transcripts on this matter that were also ruled on by Judge Wheeler concerning this same subject, I am going to adopt a similar ruling. The defense cannot give the witness immunity as it relates to any matters in which she would testify under and could properly invoke the Fifth Amendment privilege. No witness can be called to the stand simply to invoke the Fifth Amendment, as there would be no basis for this witness to take the stand and give testimony on a relevant matter that also could not affect her ability to also endanger her own Fifth Amendment right. I am going to grant the relief that is requested. If we need
How did
to
I know that
revisit
was
this
coming?
issue for any purpose where the defense believes there is a line of questioning that will not go to the Fifth Amendment privilege of the witness, we will at the appropriate time. But I do believe it is the proper ruling at this point to quash the subpoena. Mr. Laura, I believe that concludes your motion for today. Again, when it's time for your client to testify, you may place your statement on the record.
Thank you, Your Honor. Good day, sir.
To you as well. That
Okay.
concludes the public portion of the hearings for this afternoon. We will take a brief break and then resume with the in-camera matters. The courtroom is to be cleared by all non-parties at this.
Okay, so we're done. That's it, y'all. So the defense won their motion. The Donna Adelson is under only the prosecution subpoena. The defense lost their motion. I'm sorry. The defense is not going to be able to force Wendy Adelson to testify under their subpoena, so they lost that subpoena. It is squashed. She can only testify under the subpoena of the prosecution. There can be cross-examination, but if and when there is some issues with the testimony that bring up question as to information that they need, they have to handle it individually, case by case. So thank you so much for joining us on this trial. I greatly appreciate y'all. Like I said, I am running 3 trials at one time, and we are going to go back. Let me get over here and do this real quick. Let me do this real quick. We will be covering the Donna Adelson trial, FYI, daily when it does happen. So yay, but right now they're getting ready to go into jury selection. So that is why they are preparing for that. So please come join us. I have a redirect that's going to happen. Y'all, thank you so much for being here, and we'll see you over at the other trials. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.